All right, welcome everybody to our webinar on high-risk employment tools and preparing for compliance. So let me check uh, and see if we have attendees showing up, and we do. So I'm going to go ahead and get started. So my name is Shea Brown. I'm the CEO of Babel AI. We are a company that audits algorithms for bias, ethical risk, and effective governance. Many of you know me or know my content or know of Babel. Some of you are probably clients of ours. And the purpose of this webinar is to go over high-risk uh, hiring and employment tools. That's something that is a kind of a specialty of ours. We audit a number of companies, both developers and employers that use these tools. And specifically in the context of New York City Local Law 144. But now that there is some agreement on the EU AI Act, we don't know the full details of that yet, but we will be getting those details soon. I felt like it was a relevant time to start talking about sort of the pathway towards this very narrow regulation, which is New York, and there are a number of sort of copycat laws that in a number of other states, and how that sort of relates to and transitions towards this much more comprehensive and broad requirements that the EU AI Act is going to have for these tools. Some of you may be here who are not, don't have automated employment decision tools and just are interested in compliance around AI, the use of AI or high-risk AI in general. And a lot of what I'm going to say does apply. I'm going to speak very specifically about the bias audit requirements for New York and some of the requirements that we have that go beyond that, with which we implemented with the goal, knowing that the EUA Act was coming. But a lot of the stuff that I'll be talking about applies to any high-risk AI system. And so welcome and thank you for showing up. So I'm going to go through the presentation. It's just me today. I don't have nobody on my team is sort of moderating things. So I'll be presenting. You have the Q&A in the chat available. So I will take questions afterwards. So please, if you have questions as we go along, just put them in the either the chat or the Q&A, and I'll get to them at the end. And I'll try to leave plenty of time for questions here. So let me share my screen. And let's get going. Okay, so hopefully everybody can see this. So preparing for compliance. So as you can see, I've got the European Union flag here. This is telegraphing that this goes beyond sort of the very narrow regulations that are and regulators that are sort of regulating these sorts of tools at the moment. And the EU is going to sort of dominate this conversation fairly soon. So the outline, I'm going to give you kind of a regulatory roundup. Now, this is not going to be comprehensive. It's just going to be very specific, targeted ones. But I want to give us a little bit of an outline of that. I'm going to talk about audit basics. And so this is what do our audits look like for New York City. And even if you don't have us as a client, or if you're not a client of ours, all of this still is relevant for you, these requirements, and even more so as the EU AI Act comes into effect. So I'll then talk about some considerations for the EU AI Act and how what you should start doing now to sort of prepare for this, because we've got a couple of years to worry about it. But 2 years go by very quickly, and there's a lot that needs to be done. So how do you get started now? And then I'll have some some Q&A time at the end. And please feel free to ask me about the details, because I'd like to get into the nitty-gritty if at all possible. So this is Babel AI's mission statement, just to sort of level set for what we are and what we care about. We know that AI is going to dominate the future economy and society. And our mission really is to ensure that these systems are developed, tested, deployed, and governed in ways that prioritize human flourishing. That is our mission. And the way in which we are executing that is through audit at the moment. We also offer consulting services and training, but audit is the way in which we try to exercise and further this mission. That may change eventually, but we feel like that's a fruitful path now. And we have done a number of audits. This is just the ACLU's tracker for audits for New York City Local Law 144, and we feature prominently there. We've audited a number of organizations, and so we think about this a lot, and we spend a lot of time. I'm also a founding member of the newly established International Association for Algorithmic Auditors, and a fellow at For Humanity, a nonprofit that's only job is to come up with sort of guidelines and best practices for AI audits. Okay, so regulatory roundup. So this is going to be very superficial. If you do not have a regulation tracker and a spreadsheet somewhere tracking these regulations, you definitely should get one. We have one. The IAPP has one that you can make use of if you want. So I've put it here. But the pace in which these regulations are being considered and proposed, many of them fail to pass, but a lot of them have passed already. And if you're mitigating risk in your organization, you need to have a tracker for these. There's no way of getting around it. But since we're talking about employment decision tools at the moment, what I want to draw kind of a line here, and there's three that I think are really relevant here. And the first is New York City Local Law 144. And there are proposed laws in other states at the state level for New York and New Jersey. California has proposed regulations which, while they won't require audits per se, they have a lot of similar features. And in DC, there's one that's more broadly, not just for hiring systems, that's been proposed. But New York is the first one that's passed, and it's really forced action where it focuses on employers, and employers have the requirements to have a bias audit. And I'll talk a lot more about bias audits in a second. They only really consider race, ethnicity, and gender. So it's fairly narrowly focused. And it forces some transparency. They have to actually publish impact ratios, and I'll show you examples of those in a minute. So this is passed, and companies have to comply with this if they have offices in New York. Employers. However, in practice, what ends up happening is the employers will push back on the vendors, and the vendors are the ones typically who are doing these audits for the employers. There are some employers who directly do audits themselves, and I'll talk about the difference there. But it's really the first law that's really forcing this issue of audits for AI systems. Now, I've got EEOC. This is not, I mean, there are laws associated with EEOC, but EEOC, of course, is a regulator. But they are talking a lot about artificial intelligence and requirements that AI tools or companies that are deploying AI tools and developing AI tools should have. Now, they are also focused on employers. That's where they can enforce. But a lot of what they're talking about is telling employers they need to make sure that the vendors are doing certain things. So testing for bias is obviously the largest and most important issue because discrimination law is what they are enforcing. And so the focus is on discrimination. Now here, it's the full range of protected categories. It's not just race, ethnicity, and gender. There's disabilities, pregnancy status, veteran status. All of these things are covered, and there hasn't been a lot of actual enforcement action against algorithms at the moment, but it is something that employers do need to worry about when they use AI systems. Now, AI Act is the final one that I think is going to sort of supersede all of these because the requirements for under the EU AI Act is for both developers of these systems and the employers themselves. So there will be requirements, a lot of requirements for the developers, and I'll sort of run through some of those towards the end. But employers also have obligations too, as if they're using high risk. So the employers themselves, if they're using these high risk systems, they're going to have some obligations as well, including things like fundamental rights impact assessments and very non-standard kind of requirements for these systems. And so that's something that I think is going to supersede a lot of these other ones. If you are compliant with the EU AI Act as either a developer of these systems or as an employer, then you're going to, for the most part, be covered under these other two. Now, the only difference is for New York, they make you publicly publish the numbers, and that's probably a, if I were to guess, that would be not a standard thing that we're going to see everywhere. And so it's a bit of a one-off rarity, but everything else, is going to be covered under the EU AI Act. So there are many, many more that are being proposed that are relevant for this, including laws that are actually passed, like in Illinois, for instance, for certain types of video interviews and things like this. But I think these are the EU is going to cover the majority of these. So I now want to talk about sort of the audit basics, because a big part of why I want to give this webinar is, we audit companies, we can't consult, we can't get money for consulting, and audits are not super typical for these kind of systems, and so we're trying to make sure that people kind of understand what they entail, and there's going to be conformity assessments that are going to be required by the EU AI Act. Sometimes they're going to be external. Sometimes you can do it internally. But either way, I think there are a lot of elements of what we've built into the New York City one that form the sort of foundation and the nuggets that are going to grow out into a sort of full compliance for the EU AI Act. So New York City defines this requirement for a bias audit for these tools as an impartial evaluation by independent auditor. So the reason why this is very unique is that they're really specifying you need to have an independent third party come in and do these assessments. And they're really just focusing on disparate impact. And so the metric that they care about, therefore, is going to be these impact ratios. And I'll show you in a second what they look like. So if you're just an employer, so if you are an employer that you didn't develop these tools, you just have some vendor, and it's part of your workflow that you're filtering CVs or something, or you're doing a job like candidate to job description matching, let's say in your applicant tracking system, then the workflow here is actually fairly simple for what you need to do for New York. So this is for New York, but I want you to have in mind that these are things that you're going to need to do anyway, whether you're in scope for New York or not. So for New York, they really care about how does this automated employment decision tool, the AEDT, behave. Okay, employers are under the EEOC jurisdiction anyway. They have obligations in terms of who they're actually hiring. So the New York law is really focused on the tool itself, who's getting filtered out of this process. And the same thing can be said for also for promotion decisions. So this could be a candidate or this could be somebody internal. So for an employer, all they need to do, quote unquote, all they need to do is identify exactly where and how they're using this AEDT to make these decisions. So you have a candidate pipeline, let's say. This might be one piece of it. You just need to isolate and say, okay, where is this tool getting used? And then you need to start thinking about separating out the relevant data for this. So instead of just thinking about who applied and who got hired as sort of the relevant sides of the equation for data collection, you need to think about who went into this AEDT. So which applicants or which employees had their data go into the AEDT, and which one of them what subset came out of that. And so you need to isolate that and you need to collect that data. So if you're not collecting that data at the moment for a particular tool that you might be using, then you need to get that data. And so maybe you already have it in your applicant tracking system. Maybe the vendor has that data. So this is going to require you to engage with your vendor and figure out how you can get this information. But you need to isolate and collect that data. And then all you really need to do is calculate impact ratios from that data. I'm going to talk a little bit about the parameter space of the data that you collect in a second. But at the end of the day, all that New York really cares about is that you calculate these impact ratios. And there's some requirements for how it gets displayed, but really these impact ratios and selection rates are what they care about. And that's for each category so that's race, ethnicity, and gender. And another thing that's different about New York is that they care about the intersectional categories as well. So combinations of race, ethnicity, and gender. So, but this is all you really need to do. And then you need to publish it. And then there's transparency requirements as well. But in terms of the bias audit portion, this is the basic workflow. And this is an example of how the data is displayed. So these are the categories of race and ethnicity and gender. And so this is how it gets displayed. And you have to have the number of applicants, the number that were selected, you have to have selection rate, and you have to have the impact ratios. And under New York City, this actually has to be made public. And it has to be done by an independent auditor. So that's the basic workflow. So the question of data is a tricky one because a lot of people that we've talked to don't know where to start in terms of collecting this data. There are all sorts of complications, and the availability of demographic data can be one of them. Not everybody reports their demographics. What data do you select? So defining what data to use can be hard, and there are going to be different choices depending on whether you're reporting it publicly or not. So you got to decide kind of what boundaries the data set's going to have. And so if you're just worried about New York City, then you can think about geographically bounding. Maybe it's only applicants that are coming from the US. Those are the ones who are likely going to be taking roles in New York City over a particular time range. So you define what that time range is. You could split it up in terms of roles. That's not really required in the New York City law, so you can aggregate it. But you can think about what different roles you might want to separate out into. And of course, demographics. So the availability of demographic data is a pretty significant issue for New York City. I'm not going to go into a lot of the details here. I've given a bunch of webinars. I mean, you can ask about it if you want, but the Department of Consumer and Worker Protection really wants this demographic data to be self-declared. And so for an employer, this is going to be easier because you are collecting that data anyway, presumably for EEOC. So you will have that. But it may be more difficult for a vendor who has to do this. And I'll talk about the vendor workflow in a second. Well, I'll talk about it right now. So before I move from the data, so this is one of the trickiest parts, is really figuring out what data am I using. And when you're taking this boundary, it really is who goes into that tool and who comes out of that tool. That's the first thing. Who gets the pass through that tool compared to who comes in. And the decisions about time range and geography and demographics that's where a lot of the trickiness comes in. And ideally, when you're thinking about extending this a few years from now for the EU AI Act, data quality, testing and evaluation, these things are all built into the law. And so not only do you need to make these decisions, you need to justify these decisions for yourselves, and have policies and procedures around those. At the moment, you just need to kind of make the ad hoc decision about how you're going to construct this. It should be risk-based, but it will become much more significant later. So for vendors, it's a little bit more work. And well, I'm going to skip this bit because I think this goes for employers as well, but for vendors, you have a tool, and that tool can be used in many different ways by the employers. And so we have in our audit, we have the requirements for a risk assessment, and this is very specific. This is not required by the law in New York City. It will be required by the EU AI Act. We knew that, and that's why we put them in our audit criteria, that we want the organizations to perform risk assessments. And the reason is you need to be able to make informed decisions about what kind of metrics you're going to measure. So what do I mean by that? I'll just give you an example. Many of these tools are going to make ranked lists. So it could be an employee versus a job description match, and they will rank, and there'll be some sort of score associated with that. Now, New York City will allow you to use some sort of median score to create selection rates. However, what's better, I think, is for the organization to do a risk assessment and figure out what could be considered a positive outcome for our tool. Is it if you're in the top 10, if you're on the first page, if you're in a particular category, if there's categorizations in addition to the ranking? And that all has to be risk-based, and it has to be based on the understanding of how people use your tool. And so for vendors, that's going to take some exploration and like actually going through a risk assessment process of thinking about how that tool is used and documenting that process, because this is going to become relevant later. And then defining that metric, like what do we consider a positive outcome for this particular tool? And then once we have that positive outcome, we can start measuring the impact ratios, because anybody who came through the tool and got that positive outcome, that you consider that they were selected, quote unquote selected. Now, you don't have actual ability to tell who was really selected. That's the employer's job, and they make those decisions. So it's out of your control. So that's why it's important for you to really have this risk assessment in place to understand, what do you see as a positive outcome? What does it mean to be selected by your tool? And then you have to document this assessment. So Department of Consumer Worker Protection gave examples of these. So they allow for, let me move my head here. You can have an average score for these you could produce what's called a scoring rate, and construct impact ratios from those. And this is what you can do with for vendors. Now, you can either use what's called the scoring rate, which is anybody who is above the median score for a particular group, or for the median score for the entire sample, is considered selected, and those below it are rejected. Or you can choose your own cutoff based on a risk assessment, and either one of those will work, at least for our audits. Either one of those will work. So there's some caveats for vendors that I just want to highlight here. So there are definite limits on the availability of data. So you may not have demographic data. So in the case where you don't have demographic data, then you have two options. You have the option of reaching out to your employers or your clients, the ones who are using this tool, and try to have some agreement for getting that demographic data safely into your hands so that you can do these assessments. If you can't, and they won't make those agreements, then there's a possibility for inferring the demographic data. Now, the Department of Consumer Worker Protection in New York was very adamant about not wanting this to be done. And if you do have to infer the demographic data, then the testing data set is not what they call historical data. Even if it was actual people going through the platform, if you had to infer their demographics, they call it test data, if that's the case, which means it's not historical data. What are the implications of using test data to do an audit? If you use test data, then your clients can only make use of it if they do not have a statistically significant amount of their own data. So let's say you have a big client in New York and you can't get demographic information for them for whatever reason, but they want you to do an audit. You could do an audit using inferred demographics, produce these values, show them the audit. If that client has enough of their own data, a quote unquote statistically significant amount of their own data that does have demographic information, then they actually can't rely on your audit. Now, if you have a big client in New York who just purchased your system, so they don't have enough data going through your tool to report themselves, then they can make use of your audit. So if you have one of these audits done, it's still useful, and new clients of yours can make use of it until such time as they have their own statistical significant amount of data, and then they have to have their own audit done themselves. Now, the ideal situation is that you have some agreement to get that demographic information, and then you can do an audit for all of your clients. And so that's the ideal situation. Number two is employer side control of your tool. So it's pretty important for you to understand and also articulate when you're documenting this audit, the extent to which employers can control your tool, because they might be using it in ways that could lead to disparate impact that has nothing to do with your tool. You just gave them enough knobs to turn that it could potentially be a problem. So when we audit these systems, it's pretty important for us and for you to articulate for yourselves exactly how much control they have. What are the knobs they can turn? What are the different settings they can have on the user interface that could potentially impact the results and could potentially lead to this disparate impact if used improperly. Then there's employer applicability. This is the other issue. You, in theory and in general, when these audits are done by the vendor, they will aggregate all of their clients together and report those results. They don't do a client by client. Now, you can do it client by client. It's more work, but most of the time, people will aggregate. So it depends on whether that aggregation is applicable to all employers' use cases, the way they use it. And so it's important to sort of understand that piece of the parameter space. How relevant are the results that you got in aggregate to particular employers? And so when we do the audit, we want to look at sort of the variance of these numbers. Okay. So let me talk a little bit about how we conduct the audit. Some of you are our clients, and some of you will know all of this already. But this is an attestation style audit, and so the work is really done. Most of the heavy lifting is done by you, and you document this process according to our criteria, which I'll show you in a minute. And then we are verifying and validating those results. And we also dig around and really do claims verification to make sure that everything is as is claimed. But we're doing documentation review for completeness against our criteria. We're verifying claims, which a claims verification process could be as involved as really digging into the actual data set, like we get access to the data. Sometimes it's literally screen sharing and with a data scientist and having them show us results and verify results on screen share. And it depends on the circumstances. And then we form an opinion as to whether all the criteria have been satisfied to reasonable assurance. We don't do advisory services if we're auditing a client, so we can't do both. That's why we do this kind of stuff for free. We can't really make any sort of prescriptive or corrective actions. Now, oftentimes we will come back and say, this wasn't clear. You probably should do this instead of that. But we can't really hold your hand. Everything is in the audit criteria, and a lot of the critical decisions are getting made by the organization. And we don't do sort of direct testing. Now, we do a lot of verification of your testing, but we don't really do direct testing where we're going in and testing. Now, the reason for this is also because we are preparing for the EU AI Act. We're preparing for much more stringent regulations where the organization is responsible for doing all of these things. And so this was a really deliberate choice on our part 2 years ago when we embarked on this particular offering, that we wanted to get our clients prepared for being able to do all of this stuff themselves. I'm going to skip some of this document, the process, because if you were to engage with us, we would walk you through all of this stuff when it comes time. So let me look a little bit into the criteria, because the criteria is where all of the work happens, and it's a lot when you look at it, but it's really broken down into 3 components. Now, the first component is what we call disparate impact quantification, or that's bias testing. Okay, you can think about it as just either fairness or bias testing. That's all it is, and it's looking for differences in how the tool performs based on demographic groups. That's the basics of bias testing, and I've got videos on how that's done, and I can share those with you if you want. That's the basic idea. And these criteria are simply what we need to get to understand whether you've done this bias testing correctly. And we've done this kind of bias testing a lot, for not just for hiring algorithms, but a lot of other kinds of algorithms. And this is sort of like the minimum viable bias testing that you can do. And so we've tried to really streamline it. And so what we need to know is, for instance, what is the AEDT? What's the automated employment decision tool? So if there's more than one component, we want to see what's the definition of this tool. We're looking for the bounds of what this tool is. It's taking resumes in, let's say, free text. It's putting it through some sort of system, or maybe it's breaking it up into skills or different taxonomies, and it's going through some sort of algorithm. And what comes out is some sort of score for a particular applicant, right? That's a description of the system, and knowing what are the components that go into that. We need to understand the testing data. And so this is me talking, when I was talking about putting the bounds of that testing data, we really want to see, where did that data come from? What constitutes that data set? Is it appropriate? And a lot of the criteria here involves justification for the decisions about why you use that particular data set. And there's a reason for that, because you're going to need to do this for your own risk management in the future. And so having that written down, having that deliberated on is important. Which categories are you looking at? What do you define as a positive versus a negative outcome? And so you can think of this as sort of defining your fairness metric in some way. Now, for New York City, the Department of Consumer and Worker Protection, and the EEOC for that matter, has taken disparate impact or adverse impact ratios as the metric that they care about. But if you project this forward into the EU AI Act, there are other metrics that might be relevant, especially for EU anti-discrimination law. And so thinking about this is going to be relevant, and it should be revisited if you're thinking outside the US context. And getting the selection rate. I'm going to skip some of this. This is just about getting the impact ratios. I want to move on to 2 other non-standard pieces. So there are 3 components to our audit. One is that bias testing. That's the only one that's required by New York City. The 2 extra ones that we have required in our audits, and we continue to require in our audits, is governance and risk assessment. Now, the governance here is very, very minimal. All it is basically is saying, is there The first one, is there an accountable party for these risks, the risk of disparate impact? So is there somebody responsible for this whole process? Do they have defined duties? So is there like a job description? Is there a letter from the CEO? Is there some evidence that they actually have these duties? They have that responsibility, and making sure that's documented. Now, this could be a committee, it could be a person, but it's important to have somebody responsible for this whole process. And the final bit is just show us some evidence that they've actually done this duty. Now, that could be meeting minutes, that could be emails that were sent, that kind of thing. We're very flexible about that evidence. And so this is like a really super basic. Now, when we're talking about the EU AI Act, it's going to be much more, the documentation required is going to be much more stringent. But for us, for these audits, we're just having a very basic, somebody responsible for it. There's some duties, like a job description that makes it obvious that they are responsible. And then we've seen some evidence that they've actually performed this. Now, the even more non-standard here is a risk assessment. And risk assessments are something that we have done as an organization for consulting, ethical impact assessments or algorithmic impact assessments or risk assessments. But it is something that is central to all of the regulations that are being proposed. It's central to things like the NIST AI risk management framework. There's a lot of standards coming out around risk management like ISO 42001. And so risk assessments are central to this entire endeavor. And so we felt like we had to include them in our audits, if for nothing else, to start preparing our clients for what will eventually be a much more onerous process around risk management. So we have cheat sheets for how these risk assessments are done, but really all we're saying is, has a risk assessment been done? Have they actually identified risks? So, and in particular, identified risks associated with disparate impact, because that's what the law is focused on, this particular law. But there are many other risks as well, including privacy risks and other threats to people's fundamental rights. And then have they actually evaluated these risks in a real way? So not just listing them, but actually prioritizing them, thinking about them in terms of likelihood and magnitude. And so this is like, again, the minimum viable product for a risk assessment. And we put this in here really to get people's feet wet and start thinking about what is a different kind of risk assessment than the average enterprise risk management might be thinking about. It's much more externally focused, much more focused on fundamental rights and potential harm, and not just internal business risk or financial risk. So that's the requirement. So I'm going to show you a little bit of so we have resources available. So like for instance, we have risk assessment templates, and like we can give these away for free. So if you're interested in having this, our criteria also requires some calculation of some uncertainty as well. And so things like you taking the selection rate, the uncertainty in the selection rate, calculating the impact ratio, the uncertainty in the impact ratio, in some circumstances, calculating the z-score, which is sort of how far away is it from how many standard deviations is it away from the average. Don't worry about the details of that, but we have some of these available. And also we have some examples. We have a cheat sheet for the risk assessment. So those who have not done a risk assessment before, we just basically have a sort of an outline of what do you need to do. And it really is just get people in a room who have the right kind of capabilities and let them start thinking carefully about what are the real risks of these systems. We also have a bias assessment cheat sheet. So if you haven't really done bias assessments before, or let's say you're an employer, you work for an employer and you are like an HR person who hasn't really had to think about this. Hopefully you get somebody, a data scientist friend, to help you out. But if not, we've had people who are not mathematically inclined still be able to gather this information and to calculate these impact ratios. And so that's there and available. And we even have sort of examples of what risk assessments might look like. So if you are thinking about this, you could literally take our criteria, which are public, and you could just start writing narratives around this and linking documents. And it is that, I wouldn't say easy. This risk assessment process is an art, and it takes some skill to execute it well. But as a first pass, like just getting people together and document it in this way is pretty straightforward. So this is an example of how things like ranking uh, likelihood and severity and having some justifications for those. And so this is sort of like a minimum viable documentary evidence for those risk assessments. Okay, I'm going to move on to the EU Act because we're running out of time. Let me take a look at the Q&A real quick and see if there's anything that hopefully I'm not showing people's names here. Let me stop sharing for a sec. Okay, so one question was, does New York set forth acceptable selection rates and impact ratios? So surprisingly, no, they do not. So in fact, you can see public reports where impact ratios are below what would be considered evidence for impact for adverse impact. So below the 0.8. So they don't say, all they require is that you do it, you produce those numbers and you publish them. So that's and of course you can have impact ratios below 0.8 and still not have disparate impact because of it's a more complicated issue than that. And you can still legally use tools that have below 0.8 if you have certain things like validation and business justification for those. And so, no, there's no hard cutoff at all. And I don't think the EU AI Act will have hard cutoffs as well. We may see how the standards process works out, but my guess is that there's not going to be any hard cutoffs. So then another question is about sharing a link to the resources, like the template. Yes. So we'll follow up with you with like the video recording of this, the slides, and we'll just include the PDFs with that email. Okay, excellent. So I'm gonna keep going to, let's see, I felt like somebody had raised their hand and wanted to say something. Oh, okay. So the question is, how much time do you spend educating and preparing clients, like readiness for X in AI governance, including bias audits, before the team gets started on the actual bias? So the answer is almost none. So we have a lot of these webinars, and so the hope is that we have a lot of cheat sheets, and we give everything away for free. And so the hope is that the client will be prepared. And so there's a bit of a readiness assessment, like, are you ready to be audited? Do you understand? Now, some of the education comes in just simply understanding our criteria. And so we are available to answer questions about what do we mean by our criteria? And that is actually a pretty good education, just trying to understand what the criteria. Anybody's worked with standards before or tried to implement standards know that just kind of understanding what they mean is a whole process. But we try not to we don't want to prep our clients. Our clients need to do the preparations themselves. We'll explain our criteria, but we can't be holding their hands just for independence reasons. We are careful about that. But we are happy to get people prepared in general and give away free information as much as possible, because our dream is that people come prepared and we can provide a good audit experience without them needing to have their hands held. All right, excellent questions. So let me share my screen again, and we are going to get back to the EU AI Act. And okay, so why is this relevant? Why are we even talking about this? Well, the use of AI in hiring and promotion decisions are considered high risk under the EU AI Act. So this is going to be a very relevant conversation for all of you that are using or developing these tools in a couple of years. So Annex 4 Annex 3 rather. Number 4, workers management and access to self-employment. So AI systems intended to be used for recruitment or selection of natural persons, notably for advertising vacancies. So this is one that is not covered by New York, for instance. Just sort of so think like LinkedIn or other kind of platforms that are kind of advertise vacancies, or applicant tracking systems that have algorithms which will try to promote, or job platforms that are trying to promote jobs to particular applicants. The algorithms there are going to be under the high risk in the EUA Act, unless something radically changes in the next couple of weeks before this draft comes out, before the sort of finalized version. Screening or filtering applications, evaluating candidates in the course of interviews or tests. And so this is probably going to include things like remote proctoring as well, or automated scoring. Education is also in here, and so sometimes those things get mixed up, and so that's all considered high risk. AI intended to be used for making decisions on promotion and termination, work-related contractual relationships. So if you're sort of using an algorithm to figure out how much you can pay somebody, that's going to count. For task allocation and for monitoring and evaluating performance and behavior of a person in such relationships. So think Uber, Amazon, gig worker kind of monitoring, or remote worker monitoring, and used to make decisions. Those kind of things are going to fall under this. So the EUA Act is relevant here. And there are a large number of requirements, both for providers, which developers is what they mean by that, and deployers, which are the kind of users, or in this case, employers of high-risk AI systems. So the final language for the act is not done. They're working on the sort of nuanced language at the moment. It should be coming out anytime now. Maybe it's come out while I'm speaking and I'm behind the times, but I'm expecting it sometime early February, but it could come out sooner. But that's going to have a lot of requirements, and it's overwhelming. So a quality management system, which has a huge list of things, that includes risk management system underneath it. There are data governance requirements. So all the kind of standard, privacy professionals will know well the sort of data governance stuff. But beyond privacy, it will include things like the data quality. Technical documentation is going to be very important. This is all going to be a documentation. It's a paper dragon. There's going to be a lot of this stuff. Record keeping, so really keeping track of these records, transparency requirements, both for people who are transparency for people who are using the system, like candidates are going to get transparency notices. Developers need to give have certain transparency for the users of the system, and there's going to be oversight. So this is human in the loop type stuff. And they're pretty specific about the kind of requirements that are needed for that. Accuracy and robustness. So a lot of the sort of standard testing, evaluation, verification, and validation, TEV kind of concepts are going to be required under the EU AI Act. And post-market monitoring. So once you get the system operating on the market, you can't just let it run and assume everything's fine. You really got to be monitoring this system. So there's a ton there, and I mean, if you want to talk to us, we can walk you through some of this. And there's going to be standards. There are standards that are being built. Sensenelec is working on this. There are ISO standards that are relevant, that are going to specify a lot of the little details here. But most of this stuff is not going anywhere, even in the next draft. So for us, the way we're tackling this is that for our clients that we audit now, we can't consult with our clients, but what we can start introducing new audit criteria that are geared towards incrementally going towards the AI Act. And so that's what we've done. So we have new requirements, which at the moment are optional. So you can be audited just under New York City if you don't care about the EU Act at the moment. But if you've already been audited under New York, likely you formed the base, you have risk assessments, you have got some basic governance set up, you're doing basic monitoring. And so we're adding some extra criteria that's getting our clients sort of closer to what will eventually be a conformity assessment. And I'll show you some of those in a second if you're interested. So if I was starting just thinking about this, then you don't have much time. And so you got to have a responsible party. So figure out who in your organization is going to be doing this. Start getting an inventory of systems. In general, if you're a vendor, you just have one system. That's great. You just worry about that system. Start figuring out what the risk classification is. There's a chance that it's not high risk if it's used in a particular way. And so you got to figure that out. Get external help if you need it to figure out, is it going to be a high risk? But then if not, or if it is high risk, then you need to start thinking about this quality management system. And that's the thing that you will be audited against. Quality management system and technical documentation are really the things that if you were to get an external conformity assessment done, that's what they'll be looking at and verifying. And so starting to think about what's that quality management system for this AI system. This is for primarily the deployers, the developers of these systems. So those are basic written policies and procedures and instructions. So literally start a document and start writing down first, what's your strategy for compliance? So that's required in this document for the law, but it's also a required first step. What strategy are you going to have to make sure that you're compliant? And write that down, start iterating on it. And then sections from everything listed in the previous slide. So literally just have sections for all of these and start figuring out what's the minimal thing you can start doing right now that's going to be the lowest hanging fruit and have the sort of the highest impact with the least amount of burden. Get that going and start documenting it. Now, if you want to have a standard, ISO 42001 is out now, and it just recently came out. That's a pretty good starting point, and it aligns fairly well with a lot of these what the quality management system requires. It's not perfect, but it will get you a significant way towards this. So a standard like that, or NIST risk management framework is also a decent, it's pretty high level. So you have to sort of do a lot of implementation on your own, but it's there and it's good. Another thing is to start considering tooling. So there are a bunch of companies out there now that have platforms for doing this. We kind of talk to a lot of these platforms, and they have tooling for policy enforcement and logging of your system, events in your system, and people who are going to logging of permissions and who signed off on what, record keeping, testing, evaluation, verification, and validation, data quality. So start thinking about what kind of tooling do you need to keep track of all of this mess, and try to find potentially a vendor or some internal tool, or it could be something you already use that might be sufficient for keeping track of all of this. And then eventually, you're going to need a conformity assessment for these high-risk systems. So that's going to happen eventually. And it's unclear at the moment exactly for these types of tools whether an internal assessment is going to be okay, or if you need an external third party, like a notified body is going to come in, a conformity assessment body, to come in and verify that your quality management system or your technical documentation are good. So that's I'm waiting to see the final text to see exactly how that plays out. But either way, a conformity assessment is going to need to happen if you want your tool to be on the market in the EU. And if you're in the EU and you are going to use these tools, you will have also requirements. And a lot of it is just make sure that you've got the right information from the vendor that you're getting the tool from. Make sure you have appropriate training for the people who are using the tool and education. And you're going to actually have to have a fundamental rights impact assessment. I mean, at least that's what the word is that has stayed in the act, and it's going to be in the final version. And so that's something that's basically the risk assessment process. The cheat sheet I give you is essentially a fundamental rights impact assessment. It's very close to a human rights impact assessment, but it's much more outwardly focused than a typical risk assessment you do in enterprise risk management or even model risk management. So it's a different beast, and it's something that you need to think about. Okay. So This is one, this is from Article 10. Um, Bias does come up. And so to the extent that it's strictly necessary, so a lot of you might be asking, worried about demographic data. There is sort of a carve out in the AI Act that is going to let you process those sort of special categories of personal data for the purposes of monitoring for bias, this post-market monitoring. And so um, starting to have those conversations with your vendors or your clients, depending on if you're which end of the spectrum you're on, is important. There should be some data sharing agreement. It's tough in the presence of GDPR. It is a difficult conversation to have, but figuring out how that's going to work to really make sure that you can fulfill your obligations under the EU AI Act is going to be a thing that you want to start now because it may take a while to get this stuff set up. Okay, I'm going to stop here and see if we have any more questions. I've rambled on as always. Okay. So what question is, will the recording of this presentation be shared? Absolutely. Yes. So we'll send out the recording of this presentation. I'll send you the slides and those templates and cheat sheets and stuff. We'll send all of that out. So that will be available. Anything else? So in general, feel free to reach out to us. So we get a lot of our current clients in the call who want to see that, what are these extra criteria? The extra criteria are basically centered around expanding the risk assessment. So instead of just doing a risk assessment, we now are talking about a risk management, which will have risk assessment as a section, but it'll also have risk mitigation. It will have communications of those risks, and it will the way in which that assessment is done is going to be slightly different under the EU AI Act. So you have to consider things like not just the intended use, but foreseeable misuse of your tools. So kind of specific language that is in the act that will end up being requirements. And so it's an incremental step forward. And next, well, not even next year, probably in a few months, we'll integrate more criteria. And the plan is that 2 years from now, Babel will be a conformity assessment body. We're on that path, and we want to be able to provide conformity assessments, or at the very least, be able to help companies in a consulting manner do internal assessments of conformity. So either external independent or some internal stuff. We can't do both, of course, because we follow pretty strict independence rules. So let's see if we got some other questions, some more popping up. So question about the sensitive data for bias detection. So there should be more. Do you know when there's more details is the question. I think the answer is there's probably not going to be a huge amount of new information for a while. What's in the act basically is what I showed you. And I think the idea is there's more data that I didn't show that shows kind of the restrictions on what you have to have a very clear purpose for that data, and you have to have a clear policies and procedures for when that data is going to get deleted. And so it's just being careful around defining what the use of that data is. But there could be like a delegated act that will come out that might have more information. Another question is, so yeah, the question was about the audits, whether we do audits for free so we can do consulting. So not quite. So we do audits and consulting, but we just don't do it for the same client. So both are kind of a paid service, but if we do an audit for you, we can't consult. So all of our audit clients now, we're kind of stuck. We have to maintain independence. And so as we come out with new criteria, they could do better, sort of more deeper audits and eventually get to the conformity assessment place. And people who we consult with now, we're not going to be able to be your auditors in the future. And so, and there are other restrictions there. So it's a bit of a dance that we have to do to make sure that we're not, there's no threats to our independence. But yeah, good question. Somebody else said, if you provide an audit at no cost, but you also provide advisor services, can they rely on the audit? Okay, so in this case, yeah, there isn't. We wouldn't do that. So we can't audit in. So we can kind of give information away for free in this form, like doing this kind of thing. And and some of you come and become our clients, and we audit you, then that's kind of okay. Although even then, we always have to do an assessment of risk of threats to independence before we work with people. But we don't do it. We don't consult with people and then kind of do an audit for free. That will be kind of strictly off limits. All right. So we're over time now. It's really good questions. We're going to have more of these, and we're going to dive into more detail as this sort of first and second quarter of this year move on. And so you can sign up to our newsletter, and sort of look for more of these to happen, and also look for recording and other information in your inboxes soon. All right. Thank you, everybody, and have a good day.